Thank you very much, Mr. Chairman. First, I'd like to thank Mr. Carney and Mr. Nagelbauer for the work that they've done on this legislation. I believe that both sides of the aisle are concerned about getting a strong piece of legislation that will protect our consumers. This is a bipartisan issue, and we should not spend a lot of time fighting about some aspects of this initiative, but rather we should work out whatever the differences may be. From what I can understand, there are those who believe that the federal law should be a floor rather than a ceiling. And there are those who believe that where you have states who have stronger laws, we should not preempt those states. As I understand it, despite the fact that we have varying laws in our states now, they all have similarities. And so rather than thinking about this as states with such different laws that would somehow cause great complications, let's think about this in terms of the fact that we want our state attorneys generals to be involved. We want them to be involved in enforcement. I think that's very important. So let us take a look at what I think is the biggest obstacle to us getting the best legislation and deal with the preemption question. Deal with the preemption question and think about states like California. Ms. Moy, can you tell us, for example, my state, California, what are we doing with the cybersecurity? And is that stronger than what is being proposed here now?
Sure, yes, thank you. That's a good question and a good place to start because, California passed the first breach notification law years ago and has really been a leader in this area. So thank you for your work on that. California, for one thing, California recently passed a law to include login and password for account authenticators. So not just for financial accounts, but for other types of accounts as well. For example, my email account, if my login and my password were breached, I would get a notification, which I certainly would want to because there's a lot of information in there that, while it may not lead to financial harm, could lead to certainly to emotional harm if that information were breached and if it were misused. California also has a reasonable security standard, much like the federal standard right now, but California does enforce that standard and has had a number of cases over the past few years, and along with that has some very rich guidance for businesses attempting to comply with the reasonable security standard. So one thing that I think California is also very strong on is the type of guidance that the state AG's office provides to the consumers and the way that the state AG's office interacts with consumers and businesses to provide that important guidance.
Thank you very much. So I'm sure that none of us would want to interfere with states' abilities to have the strongest possible laws for cybersecurity. And so, Ms. Moy, don't you think that perhaps the federal law should be a floor and that we should certainly allow states that have tougher laws to be able to enforce those laws, and that would require the attorneys generals to be involved? Do you think that is the best way to approach this?
I do think that from the consumer's perspective, that would provide the strongest protection. And you had mentioned previously that there's a discernible pattern among the various states' laws. I think that that is the case. When you look at the various breach notification laws of the states, most of them cover a core of common information and have very similar requirements in terms of what ought to be provided in the notification, when the state AG and the consumer reporting agencies ought to be notified. And then in addition to that, some states have added on to that. And so that's where, for example, you see states like Texas and Wyoming and just this year Hawaii, Montana have added medical information to the class of protected information in order to extend protection to categories where they see a developing threat that must be addressed.
So we certainly would not want Texas to be preempted with the good law that they have, particularly as it relates to medical information, would we, Ms. Moy?
I do think that it's important not to preempt the protections for pieces of information like medical information, including other states, the very state of Mr. Chairman, Texas.
Thank you very much, and I yield back.